of Education was then under the direction of Betsy DeVos. The Office of Civil Rights in DOE relatively quickly withdrew those Obama era directives. And in November of 2018, introduced proposed regulations under Title IX dealing with campus-based sexual harassment. They received over 120,000 comments on those proposed regulations, and finally in May of 2020, adopted the new regulations that we will be discussing today. There was much discussion during the Obama period of the scope of those directives and whether they were more favorable toward victims than respondents or assailants. And following the introduction and ultimate adoption of the DeVos DOE regulations, there is continuing discussion, only it's kind of swung the other direction, where people now perceive that, particularly because of the right to cross-examine parties during the hearing process, that the new regulations are swinging toward respondents because those rights to cross-examination will be a disincentive to students reporting incidents of sexual harassment and going through what can be a traumatic experience at the hearing stage. So it's a pendulum. The new Biden administration, President Biden was actively engaged in Title IX under the Obama administration and has announced in his position paper regarding women's rights and violence that one of his intentions is to repeal or substantially modify the new Title IX regulations that were adopted last May. So much will go on in that area. There are obvious issues with repealing federal regulations, but if you are working or interested in this area, this is something that we will see evolve, I am sure, over the next year to 2 years. It's a high-profile issue for President Biden and his administration. I'd like to spend a little time talking about a number of general coverage topics under the new regulations, and then we will move to some definitions of sexual harassment under the new regs, which are the seminal starting point for application of the regs. We'll then talk about some of the procedural aspects and transition through to hearings and informal resolutions, where I will hand off to Kim and Ken and Melvin. So that's the process for the next few minutes. First of all, the regulations themselves were adopted in May. They became effective in August of 2020, and they apply to both post-secondary and secondary schools. And the regulations define post-secondary schools as including undergraduate, graduate, vocational, and professional schools. Any school which receives any type of federal assistance comes within the scope of Title IX, and it includes the vocational and professional schools. So our organization has a client that's actually a beautician school in Pennsylvania, but under the regulations, because they receive federal assistance through their students, they're required to have the policies and procedures in place under the Title IX regulations. In addition, the new regs apply to secondary schools. That includes K through 12 schools. It includes preschools, and it includes private as well as public elementary and secondary schools. So this is an all-encompassing scope under these regulations. It also applies to not only students, but also employees in those institutions, whether those employees be complainants or respondents. And we'll talk about those definitions in just a moment. There are several definitions that I think everyone should be familiar with under the new regs. First of all, the term recipient is the regulatory term for schools, and that just means they're recipients of federal assistance and subject to the regulations. In addition, there are definitions for the complainant, and a complainant is essentially a victim. it is the party who is alleging that they were a victim of sexual harassment. The other term is respondent. The respondent is the alleged perpetrator or assailant of the incident of sexual harassment. So throughout the regulations, the terms are complainant and respondent, and we will use those terms in general throughout our conversation here today. In addition, there are a number of positions outlined in the regulations to be filled by either school-based employees or outside providers. The first of which are Title IX coordinators. Every school is required to employ a Title IX coordinator. So that is an employed position. That is the individual who is charged with implementing the Title IX regulations and ensuring their compliance on campus. In smaller schools, those Title IX coordinators may be an individual who has several titles. So there are schools out there who use their HR directors as Title IX coordinator. It may be an assistant provost. It may be someone in their administrative department, but someone who wears multiple hats, one of which is being the Title IX coordinator. Larger schools generally employ a full-time Title IX coordinator, and many of the largest schools will have multiple assistant Title IX coordinators to work in that department. In addition to the Title IX coordinator, schools must have investigators to investigate any alleged incident of sexual harassment. Those investigators are school-based in many cases. They're school employees. In the larger schools, they're full-time, normally experienced investigators who work on a routine basis conducting Title IX and other types of investigations on campus. In smaller schools where budgets and the number of cases limit the ability to hire and maintain a full-time investigator, those schools will use part-time investigators. So it may be a basketball coach, it may be an English professor, it may be the provost of the school. They generally have a limited training. Most of them have never done any type of an investigation or witness interview previously, but they are designated as campus-based investigators. And frankly, that is perhaps a problem for many of them down the road. But those schools as well, both large and small, may engage outside investigators, professional investigators with experience dealing with Title IX cases or otherwise, who will come on campus to do the investigation, complete the project, and then move off campus again. So in addition, the regulations provide for decision makers or hearing officers, the individuals who make the ultimate determination of responsibility in a Title IX case. There are also appeal decision makers, which cannot be the same as the decision maker hearing the initial case, and schools must provide an appeal process for any determination whereby the complainant or the respondent can appeal the decision on limited basis under the regulations. The regs also provide for facilitators or individuals who are charged with facilitating informal resolutions of these cases through mediation or arbitration or restorative justice or other forms of informal resolution. And we'll talk briefly about that in a few minutes, and Kim, Ken, and Melvin will spend some time in more detail on that option under the regs. And finally, under the regulations, there is a provision for students to have advisors, both the complainant and the respondent, to assist them during the course of a Title IX investigation. And these may be attorneys. They do not need to be attorneys. It can be anyone from a professor to a counselor to another student. Since it's now defined and required in the regulations, at least to be available to complainants and respondents, and mandated when they reach the hearing stage, because only the advisor can conduct the cross-examination of the other party and witnesses. it's an area for many schools that is undeveloped because they've not had to deal with it to that extent in the past. So I think we will see that area develop as well. I wanted to point these multiple positions out at the beginning of this conversation because I think that as the development of implementation of these regulations goes along, I think many of us as practicing attorneys will encounter the opportunity, so to speak, to serve in one or more of these roles. So some of you today may represent colleges, junior colleges, elementary or secondary school districts where you are advising your clients. Others may be called upon to serve as counsel to students during these processes, in which case you are filling the advisor role, and others may have an opportunity to serve as decision makers or mediators during the process itself. A couple of things to keep in mind here. The Title IX regulations apply to cases which come within the scope of Title IX, and we'll talk about what brings them within that scope in a minute. However, many schools will expand the scope of their sexual misconduct policy to address areas that are not within the scope of Title IX. So for instance, Title IX, the regulations under Title IX provide that it only applies, and the processes under Title IX only apply to incidents of sexual harassment that occur within an institution's educational program or facilities. So if a student is a victim of sexual assault at a bar on a Saturday night, that does not come within the scope of these regulations, and the school is not required to follow the Title IX regulation guidelines and requirements. Similarly, the Title IX regulations only apply to incidents occurring within the United States. And if an incident occurs involving a student while studying abroad, that particular incident is not within the scope of the new Title IX regulations. Many schools will adopt a process that is more expansive in that it will cover a broader definition of sexual harassment. It will cover student-on-student incidents that may occur on campus or off campus, and it may cover students while studying abroad. So the definition of what comes within the scope of their code of conduct is broader than the definition of sexual harassment and the jurisdictional criteria under the Title IX regulations. Assuming that's the case, some schools will still follow the Title IX protocol for initiating a complaint, initiating an investigation process, and the hearing process, the same as provided under Title IX, whereas other schools will follow a different process for those non-Title IX cases. So the investigation process may be different. The hearing process may be different. It may be more streamlined. It may involve a different standard of proof because they're not obligated to follow the Title IX guidelines. So anyone working in this area, one of the first things you need to do if you're engaged with a school is to review their policy and understand clearly what the criteria are and what policies and procedures come into play. General guidelines under Title IX. The process must be prompt and equitable in dealing with both the complainant and the respondent, and you will see throughout the regulations reference to the treatment of both parties being prompt, equitable, and equally treating both parties. The schools must also provide that school-based or outside-based investigators, Title IX coordinators, decision makers do not have a conflict of interest or bias toward either individual complainants and respondents or complainants and respondents in general. And schools are required to have a process in place to ensure that those parties do not suffer from a conflict of interest or bias. And lastly, As I mentioned earlier, schools have the flexibility to outsource their Title IX investigation and adjudication functions under the regulations and the preamble directives um, as they feel appropriate. Some people believe that schools are inherently biased when they're dealing with students, but that's not an absolute bar under the terms of the regulations. I'd like to move to the definitions of sexual harassment because this is kind of the foundation for the application of the Title IX regulations. There are three distinct classifications of sexual harassment under the regs. The first is quid pro quo type incidents of sexual harassment, where essentially an individual related to the school is conditioning some benefit on an individual providing some type of sexual relationship. Typical example is a professor who engages a student in a sexual relationship in exchange for a grade. These incidents can be either explicit or implicit, and it can be a single incident or multiple incidents between the parties. Pretty straightforward. The second that I'd like to touch on, and they're out of order here for the moment, is sexual assault, dating violence, domestic violence, or stalking. And if you're looking at the materials, this is on page 5. The definition of sexual assault is initially forcible or non-forcible sex offenses under the FBI's Uniform Crime Reporting Program. And the UCR begins by talking about sex offenses as any sexual act directed against another person without the consent of the victim. So without the consent of the victim, including instances where the victim is incapable of giving consent. And you'll see then the specific definitions of forcible rape and forcible sodomy, sexual assault with an object, and forcible fondling, all again reference consent and the ability or inability to give consent or incapacity. For anyone who's read anything about incidents of sexual assault on college campuses, the issue of consent is pervasive in many of these discussions and cases. There are very few cases of campus sexual assault involving somebody jumping out of the bushes. Most of them are not black or white, they're gray. Students who are drinking, students who have been using drugs, students who have had a relationship of one sort and it has either changed, they've had a social relationship that becomes sexual, they've had a dating relationship, they break up. There are all kinds of gray areas involving the question of when a student gives consent, and frankly, when the respondent may have recognized or not recognized that the complainant gave consent. The regulations themselves do not contain a definition of consent, but do mandate that every school adopts a definition. You should note too that many states have their own distinct college sexual assault statutes that impose guidelines for schools setting up sexual assault prevention programs and providing for investigative processes and hearing processes. And within those statutes will contain a definition of consent that the school is required to adopt as it relates to their sexual misconduct policy. Finally, the third type of sexual harassment is noted on page 7 as unwelcome conduct determined by a reasonable person that is so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the school's education program or activity. This is what is known as the Davis standard. It's adopted from a Supreme Court decision in Davis versus Monroe County Board of Education. This is the most subjective, and I think the definition of sexual harassment that gives most Title IX coordinators heartburn and forces them to lie awake at night, because it's obvious that these criteria are so subjective in many cases that it's very difficult to determine whether you have an incident that fits within these definitions. So you first of all have to define who is a reasonable person. Maybe I am, maybe I'm not. Secondly, you have to determine whether an incident is severe, and what may be severe to me may not be severe to Ken or to Kim or to Melvin. Beyond that, what is pervasive? And this is really a difficult question in many instances. So if a single student has some type of sexual conduct with another single student 5 times, is that pervasive, or does it need to be 10 times? Or what if that student has a sexual contact with 5 different students 1 time each? Or what if an organization has 10 members and they have the same contact with 10 different other students? Is that pervasive? There's no clear definition. This is all that's in the regulation. So, but it's obviously a subjective question for many instances. And finally, what's objectively offensive? I think some things are black and white, but many things are gray. So this particular area will cause, I believe, a significant amount of litigation as we move forward with trying to address this definition and deal with it through the grievance process under Title IX. A recipient's response under the regulations, and I'm on page 8 of the materials. There are 4 criteria that have to be met in order for a school to be required to address an incident of sexual harassment under the Title IX regulations. The first of which is that it be an incident that constitutes sexual harassment under those definitions that we just discussed. So if it's an incident that does not come within that scope, including that Davis standard, then it's not an incident of sexual harassment under the regulations, and the school is not required to address it under the Title IX regs and processes. And as I mentioned earlier, the school can still have its own code of conduct and a sexual misconduct policy, but it will not trigger Title IX. Secondly, the school must have actual knowledge. For universities and post-secondary schools, that means that the Title IX coordinator or an individual who is responsible for Title IX implementation, if they have knowledge, that's actual knowledge. If an RA or a professor has knowledge of an incident, they are not charged with the institution having actual knowledge unless they report it to the Title IX coordinator. However, at K through 12 schools, secondary schools, that school is charged with having knowledge if any employee has knowledge of an incident of sexual harassment. Much broader and problematic, I'm sure, for many K through 12 school programs. Thirdly, as I mentioned earlier, it must happen in the program, education program or activity of the school. And finally, the incident must have occurred within the United States. If any of those 4 criteria are not met, that incident does not come within the scope of the Title IX regulations, and the school is under no obligation, under Title IX at least, to conduct the processes that are mandated under the regs. Still can be subject to the school's code of conduct. An interesting question that we won't spend any time on today, but the regs note that school programs might include online sexual harassment, depending upon the context of the online communication. So if it's some type of sexual harassment in a school-sponsored class, that may come within the Title IX scope. If it's beyond the school's program, it would not come within Title IX. What must a school do upon becoming aware of an incident of sexual harassment? Regardless of whether the complainant files a formal complaint or not, the school is charged with providing supportive measures to the complainant. And supportive measures, schools have, most schools are familiar with this. They've been providing supportive measures in one form or another for these situations for many years. But these include counseling for the complainant, extensions of deadlines for classes, moving the complainant and respondent to different classes so they don't have contact with each other, no contact orders, um, changing dorm arrangements so they're not living in the same building, providing increased security. There are a whole variety of supportive measures, but schools under the regulations, if there is a Title IX incident, are required to provide those supportive measures to complainants. And obviously that may require some um, adjustment of a respondent's schedule or living conditions. There's little direction on that, but obviously it should not be punitive because there can be no punitive measures taken against a respondent under these regs unless there's a determination of responsibility at the conclusion of a hearing. So it may be a bit disruptive to a respondent, but it cannot be punitive. I'd like to transition here with the grievance process. I think I have about 2 minutes left in my segment. I'm looking at page 12 of the outline materials. If a complainant wishes to initiate a formal process or grievance process, as it's referenced under the regs, the first thing that happens is the complainant files a formal complaint. And while anyone can report an incident of sexual harassment and trigger a school's need to provide supportive measures, only a complainant or the Title IX coordinator can initiate a formal complaint and trigger a formal investigation. The investigation proceeds through the initiation of that formal complaint. The investigator is charged with interviewing the parties as well as witnesses, preparing an investigation file and providing that file to both the complainant and respondent and their advisors to provide input before the investigator completes his or her report and in turn submits that report to the Title IX coordinator, at which point the case moves forward to the hearing process. I think that Kim and Ken and Melvin will talk a bit about standards of proof, so I'm not going to touch base on that. The last thing I would comment on, though, is the fact that in these cases and under the regulations, the investigator is required to turn over the full investigation file to both parties for their review and comment, and the file must be made available at the hearing. Prior to the regulations, many attorneys served as counsel to the school and also conducted the investigation itself. I believe that going forward, very few of us will engage in wearing both of those hats, because I believe that if we are trying to counsel a school client as to how to address issues in a Title IX investigation, while at the same time we are conducting the investigation itself, it's going to be very hard to justify attorney-client privilege when you're talking to the Title IX coordinator and then pivot to put on your investigator hat and not have to disclose those communications. And I think it's incumbent upon us to recognize and to advise our clients that frankly, they probably should have independent investigators from counsel advising the school on that particular Title IX case. So thank you for your time. There are obviously substantial materials for your review. The PowerPoint kind of follows through, but I appreciate your time and attention today, and thank you for attending. Rob?
Pat, thank you so much. Outstanding presentation, and I would call everyone's attention to the materials that Pat has, all of which were, the link to them were emailed by Kelly of our office to you. And if someone by chance misplaced that link, you can email Kelly and she will email the link to all these terrific materials to you. The next part of our program that deals with Title IX is more focused on the mediation side as well as the decision-making side. I'll ask Ken Chackus, Melvin Kennedy, and Kim Kern to mute themselves. And I should also mention that Ken, Melvin, and Kim are all neutrals with USA&M. And they're part of a select team within our organization that has received specialized training in Title IX issues relating to hearings, making decisions as the decision makers, as well as mediating. And it was these regs that went into effect last May that allowed mediation for the first time. So Ken, Melvin, Kim, and I, as well as Jim Reeves, Mike Geigerman, Judge Michael Jameson, Judge Pat Reel, and Karen Tokars from WashU are all part of this team in being available to mediate and to serve as hearing officers. Kim, I'm not sure who's leading off your program.
Me.
Without further ado, Kim Kern.
Wait, let me ask if my screen sharing worked.
Yes.
Okay.
Can you show the entire PowerPoint? You know, not the slides on the side. Go to slideshow and then start.
Okay.
You should get a drop-down menu.
From
Like
beginning.
from beginning, yes.
Yeah. Oh, yeah, that's nice.
Okay. Oh, that's not nice. Welcome, everyone. My name is Kim Kern, and I'm so pleased to be with you on this beautiful winter afternoon. I am coming to you remotely from my home office, and yes, indeed, I am wearing house slippers. So I hope you are too. I hope you're comfortable. I have the pleasure of talking to you with my two colleagues, Ken Shakis and Melvin Kennedy. They both have lots and lots of experience as litigators and as mediators. And I come with some experience. I spent 12 years as legal counsel at Southern Illinois University, Edwardsville. And then another 10 years doing lots of work on with both K through 12 as well as institutions of higher education, and have served as an investigator. I have served as a mediator for many of those cases, including special ed cases. So our goal is to try to take what Pat went through and talk about it in terms of the practical application and you know, and what we have seen in our work with educational institutions. And so I hope I'm not repeating him, and I'll try not to. If I do repeat, it's because I'm trying to put a practical spin on it. Okay, so next slide, please, Ken. Great. One of the things I would encourage you to do if you're doing any work within this realm is to always make sure you're checking back with Department of Ed. What is the current status of the law as well as the regs? Title IX, the law isn't going to go away, it's not going to change, but the regs, I mean, these regs were issued under the prior administration, under the prior Secretary of Education. We now have a new administration, so I don't think any of us know exactly what's going to happen with these regs. So make sure that you're using the most recent version. So that's sort of guidepost number one. The second guidepost I would ask you to always be aware of is state law. And because there are very many statutes out there that deal with, of course, sexual harassment. So for example, the Illinois Human Rights Act has a section that specifically deals with sexual harassment in education. So you'd want to make sure that's your second guidepost. Is there a state law that I need to be aware of? And then thirdly, make sure you're looking at the institution's Title IX policy directly. There are some options given to schools. And so in that policy, they'll be choosing which option they want. But you also have schools. So for example, I did a case not that long ago with a school that was religiously based. And so they were exempt from Title IX. However, they decided that a lot of the provisions in the Title IX regs were good, and they wanted to bring them into their campus. So they had Title IX regs, even though technically they were exempt from the regulations. Private schools also, you've got single sex schools, historically Black colleges and universities. So even though they may be technically exempt from the law or exempt from the regs, they may still be pulling parts of those regs into their policies. So that would be your third guidepost you want to look at. So, you know, the Department of Ed regs, state law, the institution's policy itself. Next slide, please. Great, thank you. So when the 2020 regs came out, they were quite controversial, and they made some important changes, and they made some good changes. I mean, some people criticized that they had a lot of bad changes, but they did have some really good changes, and we're hopeful that those changes will stick around. And of course, one of them is mediation, so we're going to talk about that. I wanted to give you an example of some of the differences between K through 12 and higher ed. And I do work on both levels. So, and they are very different. You know, I mean, I think that's important, but I gave you an example of notice to the school, because once the school has this, you know, notice, they are under an obligation to respond. So when do you have notice? And what I found when I was working in-house at a university is that a student might feel comfortable talking to her RA, or she might feel comfortable talking to the graduate assistant that's teaching her physics class. Well, are either one of those people technically employees of the university? They're certainly not full-time employees of the university, but yet they are receiving some compensation. So I love when Pat said, you know, these are not black and white situations. I would tell you, they are never black and white situations. They are always, they're more than 50 shades of gray. There are 150 shades of gray. And you really want to look at the facts behind it.
Kim, may I interrupt for a second? I
Yes.
think the slide's not showing the full slide to the presentation. I think I'm only seeing a snippet of the slide. I'm not seeing very much of it. And I think that may be
Ken,
the same
can you,
for listeners.
Can
I
you
don't
pop
know.
the whole slide up?
I don't know. I see the
Sorry
whole
about that.
slide.
Yes, I'm only seeing a snippet too, but I was thinking you
Oh.
guys were.
I don't know. I see the whole slide. Rob, do you want to try yours?
Yeah, try that. I
will, and Kim, go right ahead and we'll
Okay,
see
thank
how we
you.
can do this.
Yeah, Melvin, thanks for letting me know. I didn't realize that. A practical tip I would give you is choose your Title IX coordinator wisely. When I was acting as counsel, our Title IX coordinator was our director of athletics. And I think oftentimes it is someone in the athletic department, but of course Title IX applies to the whole university. It doesn't just apply to the athletic department. And maybe that's changing and it's moving back more into the sort of academic side of the house. But just choose your Title IX coordinator wisely. Make sure they have access to good training. I'd also encourage you, as a practical tip, watch your timelines, because your policy may have some very tight timelines for turning around an investigation, for turning around a decision, or for holding a hearing. And you'll get in a whole lot more trouble not meeting a timeline than you will perhaps not getting the decision right, which, you know, is obviously putting form over substance, but that can be a real issue. If you are going to struggle and not meet a time frame, try to get a hold of the parties and have their consent to a short extension. But do watch those timelines. And then questions of who's going to act as an investigator, and do you want that in-house or do you want that somebody who's external? One thing that we had at the university was a human rights coordinator, and that person actually was an office with a couple people, but they had jurisdiction university-wide. And they were able to do some really good investigations coming in as they were within the university, but yet they had quite a lot of power and were separate and, trained in doing investigations. All right, it doesn't look like our slides are working.
We're
Ken,
trying.
do you want me to try?
Yeah, I don't know why you're not seeing the whole thing.
All right. Oh, there you go. Do you see it now?
I see the whole thing, but
Melvin, what do you see?
If it ends and parties can stop at any time, that's what I see the whole thing. It looks better. Yeah.
It's still only showing a partial.
anybody know how to fix that? Let's get the IT in here.
Ken, I'll try to take it. Kim, why don't you keep talking and we'll fix this.
Okay. Sorry, let me get my Zoom back up. Thank you. Okay, next slide, please. Good. All right, you're on mediation. So
Yeah.
One of the important things that came up was in this new regs is that we can do mediation. It's referred to as informal resolution or restorative justice. It's similar in a way to what we do in court. You can't require it, and most mediation is voluntary, so you can't require it. You also cannot use mediation or this informal resolution if the respondent is an employee. Now, that doesn't mean that you can't act. Of course, you can still take action against an employee who's sexually harassing, a student or somebody in an educational institution. But you'd want to look at your collective bargaining agreement. You'd want to look at progressive discipline or your employee handbook to see what you can do. What we're saying is that these very, very specific Title IX regs and the informal resolution isn't going to apply if the employee is the respondent. You have to allow the parties to stop at any time, same thing as a regular mediation, so you can call an impasse and get back. Beware if there are criminal proceedings pending, and sometimes there are, because your respondent is going to be walking a very fine line between what their lawyer wants them to do in both of those instances. So just beware for that. I'd also ask you to consider, what do you want to do if there's civil litigation pending? And I remember at the university one time a complainant was unhappy and sued us. And so we were sitting around trying to figure out how we were going to handle this case. And someone said, "Oh, this is just terrible. I can't believe the complainant has sued us." And I said, "Well, things could be worse. We could be sued by the respondent as well." And that happens, believe it or not. You'll have at an educational institution, you will make both sides so mad that they will both sue you. And so it can get worse, believe it or not. And then you want to think about, in mediation, is there an unrepresented party, and how do you want to handle that? And it's just something to think about, how you're going to resolve all of this within the context of a mediation. But it's a wonderful option, and I'm so happy that it was included in the regs. Okay, next slide, please. One of the things you want to look at that has happened to me a lot again is the conduct very specifically covered by Title IX. So conduct occurring off campus. And, we can all agree that something that happens in the residence hall, on campus, well, clearly that's covered by, Title IX and is a part of the university's responsibility. But oftentimes the cases that were some of the more difficult ones were cases where the conduct occurred between two students, but it occurred off campus, at a bar or after the bar closed. So clearly there's no, educational component, yet both the complainant and the respondent are both students. One thing again that I saw a lot is one or both of the students will withdraw from school. And the issue that comes up with that is that sometimes the sanction is, that the student, the respondent, is allowed to maybe finish the semester, but then is not allowed to re-enroll for 1 year or 2 years. Well, what does it matter? You know, if the student is withdrawing, then what does it matter? And then you really have issues when your complainant withdraws, and that happens too. Issues where the complainant refuses to file a formal complaint, yet you obviously have notice of something happening and how you're going to handle that. Or conduct that's brought to your attention, but that has happened many, many years previously. Okay, next slide, please. And then I just wanted to spend, next slide, please. Yeah, okay, thank you. And then I wanted to spend just a little bit of time on the types of complaints you might see under Title IX. Certainly harassment going on between students, but also cases where there is a consensual relationship between the students, but then it becomes non-consensual. There, you know, sometimes date rape allegations, but then later the relationship turns back into a consensual relationship, and very, very tough issues factually. Sexual comments made by faculty members, and I'd encourage you, of course, to look at context when that happens. What's the class? My good friend teaches human sexuality. Of course, they're going to have discussions in their class about sexuality versus, you know, a sociology class or something. Bullying in the classroom. This is an issue particularly where you maybe break up into small groups, so the faculty or what's happening isn't seen by everybody, but just a small number of people. School bus ride with the girls and boys basketball team going to the game. What happens in that bus? I mean, there's a lot of just unusual situations that you don't see in a regular working environment. Coach and athlete relationships. And then probably the one that surprised me the most during my years in higher ed was student employment. And a lot of students have jobs on campus, and they're working closely with employees on campus, and sexual harassment, inappropriate comments, sexual relationships develop, and it was an area that I never imagined I would be working in. Okay, so at that point, I'm going to turn it over to Ken. Thank you so much. I'm happy to answer questions later or by email.
All right, I think Melvin is actually next.
Oh, sorry, Melvin.
All right. So as Rob stated earlier, I'm Melvin Kennedy, and I do mediation through USA&M. My bio is probably available to you, so I'm going to move right on. We're a little behind. In prepping for the hearing, so you need to familiarize yourself with the institution's hearing process. It may vary from institution to institution. And by that, I mean, you know, what's going on, what's available to your client? What informal, if there's informal resolution available, what supportive measures are available? What type of hearing, what type of process are you in? Are you in the code of conduct process? Are you in the Title IX process? Do they mirror one another? Are you in something separate from that? Maybe in an employee student process that may be slightly different. You want to know what the standard of proof is. And, you know, the student gets to choose between clear and convincing evidence and preponderance of the evidence. You want to ask questions about at the hearing, what order of questioning is there going to be? I mean, you're in all likelihood going to be allowed a pre-hearing conference with the panel or the hearing chair, depending upon how the process is set up. But you want to know the order of questioning. The regs don't really set out for you. It sets out cross-examination by advisors, but it doesn't state that the advisors get to walk their client through testimony and direct. The panel may ask the initial questions, and you have to make plan for that, because one of the criteria for the hearing chair not allowing questions would be relevancy. And to the extent that you're the third person asking the same question, you may not get to get that question in. But those are things you want to talk about in a pre-hearing. You want to know witness availability. You know, if you're relying on some witnesses who maybe have scheduled a trip that they can't avoid, or they're unwilling to participate, or anything along those lines, you run the risk that that their testimony, even if given prior, will not will not be useful to you. I mean, the regs say that you know, the panel cannot consider the testimony of somebody who does not make them available for make themselves available for cross-examination. So if a supporting witness or your witness can't be there, that's going to be, I think, hugely problematic for the evidence you're trying to put on. I think, next slide. Okay, so understand you're not going to be in a courtroom. The rules of evidence, generally speaking, will not apply, although the hearing chair might borrow some. Those are things that you'll learn in your pre-hearing conference. You want to ask those questions. You know, to what extent am I going to be able to do X? You know, there's no provision in the regs for how that's. You know, the chair has to rule on relevancy. Only relevant questions are allowed. But how's that going to be done? Is that going to be done? One possibility is that you might be asked to submit questions at pre-hearing so that a determination could be made on relevancy of a number of the questions. And that probably will assist the flow of questions. But obviously, in cross-examination, there are going to be things that are going to come up that you'll want to ask about that you would not have known about in pre-hearing. And so you just want to get a sense of how that's going to happen. Is it going to interrupt the flow, or is there a way that you can suggest to the hearing chair that the questions get out in a way that helps you not break the rhythm of the questioning? Let's see. Okay, the sort of guiding premise of Title IX is compassionate, trauma-informed inquiry. You know, what does that mean? I mean, I think generally the notion is that you're considerate of the fact that it's a sensitive matter, a sensitive subject matter for everybody involved, and that type of questioning is the type of questioning that should be asked of both the complainant and the respondent. But quite frankly, we're not all equally able to ask compassionate, trauma-informed questions. You know, particularly if you get into cases where you've gotten lawyers who are just used to being an advocate. Yeah, and the other question is, what if you cross the line? Those are questions you want to find out. What if you know, is there an admonishment that you don't get to ask the question if it turns out you're not able to fully conform there? You know, those are just things to keep in mind. Let's see. Yeah, and just understand that there's no provision for objections in there. It's just not court. You know, beside the you know, the hearing chair makes a determination on relevancy without an objection. Although there may be things that you suspect will be delved into by the advisor of the other party that is objectionable, and you have the right to object to certain things. For instance, if you have the notion that, let's say, if you're representing the complainant and you have the notion that the other advisor may be trying to get into your client's past sexual behavior for a reason that would not be permitted under the regs. Those are things that you certainly want to know going in. You want to bring that up at pre-hearing. You want to figure out how that's going to be addressed. Next slide. Okay. In addition, the regs, you know, mandate that they institution provide an appeal process to both parties. You want to know what that appeal process is. And you want to weigh, as Kim pointed out, Title IX does not trump any other laws that might also cover the conduct that's being complained of. And the institution has within it, at least prior to, let's get back for a second, prior to the hearing, I think, and maybe anywhere up to the hearing, if one of the parties withdraws from the institution may dismiss the proceeding. And let's say, for instance, you're representing a respondent and there's concurrent, I don't know, criminal action that might be pending. You might want to consider whether you want to do the sort of that dance of being in a forum where your client might say something harmful in a more, I don't want to say more serious proceeding, but a proceeding where your client's liberty interest may be implicated, more so than just being expelled from school. You may want to consider that, what the possible ramifications of just not participating as a respondent. Let's see. I'm having some difficulty with reading the small print. Let's see. The basis for appeal. The parties will be able to appeal the determination regarding responsibility. Both parties have that. The institution's dismissal of a complaint may be appealed. And that would be only the complainant wanting to appeal that one for sure. Procedural irregularities. If, for instance, that obviously would include a determination that some line of questioning that maybe you wanted to pursue in cross-examination was not relevant, that certainly gives rise to, I think, an appealable right. If there is new evidence that is presented that hadn't come up, and maybe that evidence is not allowed fully, or you feel like the hearing panel didn't properly deal with that certainly would be a reason for appeal. Conflict of interest, just as Pat was mentioning earlier about counsel for the recipient being their counsel and playing some other role in the process. That may be something that, if it were to come up, that would be a basis for an appeal as well. So the overriding watchword is just know the process that you're in. The regs give some flexibility to institutions in setting up how they want to comply with the regulation, and to the extent that there's subtle differences between one institution and another, you do want to make sure that the playing field. I think I think the next slide may be Ken.
Very good.
Right. All right, thank you. I'll not try not to repeat anything that's been said so far, but I'll refer back to it. So I'm going to talk about what happens at a hearing. And you've heard that the school is responsible for conducting a thorough investigation before the matter gets to a hearing. And so one of the big questions is what happens to that investigation in the context of the hearing itself. So it's very important to, if you're a lawyer representing one of the parties to the hearing or the school itself, you have to be very familiar with that investigation report, because that'll be provided to each party and to the hearing officers before the hearing. And each party can actually respond and ask more questions to the investigators and get a quick response before the hearing, in theory anyway. So the investigation report is very important. And this, as has been said before, the school policies are going to be very different. There's a lot of leeway allowed One of the school policies that we looked at requires investigators to attend the hearing and provide a summary of their report at the hearing, and then be subject to questioning by the hearing officer and the parties. Most of us didn't think that was a great idea because the investigative report itself is not considered direct evidence of anything. It's going to all be hearsay, of course. So it could be a waste of time because the parties are allowed to use their own witnesses. And so before the hearing, let's move to the next slide. There can be a pre-hearing meeting, and that can be very important. It can be like a pretrial conference in court where the questions and the issues are discussed to determine what's going to be relevant and what's not. And to shorten the hearing, the decision maker is allowed to decide if the parties agree, the regs say with full agreement of the parties, that certain witnesses do not need to be present if their testimony can be adequately developed just by reading the report itself or previous witness testimony. So let's move on to the next slide and start talking about the hearing itself. The regs require that for colleges and universities, the school has to provide a live hearing. But then the regs go on to say that can be, it can be a virtual hearing where parties are either in different rooms, but have virtual access to each other so that they can see each other at all times, or they can be at separate locations like we're getting used to here with Zoom. Even if it's a live hearing with people actually gathering in the same place, a party can request that parties be divided into separate rooms. If because of the nature of the relationship between the parties, one party doesn't want to see the other party, the hearing officer can allow the parties to be in separate rooms, again, with technology available so that they can be seen by everybody. For the pre-college level, elementary and secondary schools, a live hearing is not required. A hearing officer in that case can make a decision just by reviewing the investigative report, submitting written questions to parties and witnesses, get answers to those questions, have a follow-up process. So a very, very different kind of process can be provided for elementary and secondary school hearings. So the question then becomes at the hearing, how does the evidence is presented? And that can be done in very different ways. The regs talk about an advisor, that each party is required to have an advisor, which can be an attorney. And if the party does not have their own advisor, the college or university must provide one at the school's expense. Again, the advisor doesn't have to be an attorney, but there has to be an advisor for cross-examination. But the regs don't say anything about direct examination. So I would imagine that a lot of hearing officers would conduct the hearing in the normal way a hearing is conducted, where each party gets to put on their own direct evidence and then be subject to cross-examination, which has to be done by the advisor, which may or may not be an attorney. The regs specify that if a party or a witness is not willing to submit to cross-examination, the decision maker can't rely on any statement of that party or witness in reaching a decision. Melvin talked about those relevancy determinations, which according to the regs, a relevancy determination must be made by the hearing officer before the question is answered. And it doesn't say anything about objections. So there's been some discussion that there has to be a pause. Every time a question is asked, the hearing officer has to make a ruling. I think it could go a little smoother if the hearing officer announces ahead of time that, give me a chance to get in there. But even if there's not an objection, assume that I'm going to allow it, and it'll be determined relevant unless the hearing officer jumps in. Otherwise, it could get very unwieldy, and a lot of that can be covered in the pre-hearing conference that we've talked about. So then there are also in the regs some specific rules about the complainant's sexual predisposition or prior sexual behavior. The general rule is that evidence about that is not relevant, with two exceptions, one being to prove that someone other than the respondent committed the conduct, or also specific incidents of the complainant's prior sexual behavior with the respondent can be offered to prove consent. If the issue is consent, the respondent can put on evidence, well, she did it before. Then there's also this provision that medical or other similar privilege records are not available unless the party gives written consent. So there's no way to subpoena and get any kind of medical or other privileged records for a hearing. Next slide. Was mentioned also that standard of evidence can be either preponderance or clear and convincing, and that's up to the school. Another reason why you have to look at the school's regulations. There's another provision about that I think is important, that when it talks about burden of proof, the only place where the regs talk about burden of proof that I noticed is that it says the burden of proof and the burden of gathering all the evidence is on the school. So again, that investigation is very important, so such that the school has to perform a thorough investigation before getting to a hearing. Next slide, please. I think I'm probably over time. There's specific requirements about what has to be in a written decision, and a written decision is required that goes into a lot of detail. And then we can go on to the next slide. The decision is final. As soon as the appeal time limit has run, with neither party filing an appeal. So that is our presentation. We've provided our phone numbers and email addresses for questions, or if Rob has time and any he wants to pose now, we're here.
Ken, thank you. And Melvin and Kim, thank you all for your presentation. All three of you have agreed that if any of the attendees have questions, that they would entertain those via email and would get back to you. And Pat Mathis has said the same thing. Why don't we take just a minute to stretch our legs, and then we'll start back up with our next segment with Steve Ringkamp. We'll see you in just a minute. So Steve, why don't we go ahead and plan for you to go until, let's say 3:40.
Rob, I'll get you back on time. I know everybody likes to stay on time on this stuff, so I'll
Okay,
take care of you.
fantastic. Thank you much.
Just let's keep it on time. Just let me know.
I'll do it. I'll do it. So folks, why don't we continue on? I want to make just a couple of brief announcements before we get started with Steve. First and foremost, there is an evaluation in the materials. I think it's about the second page, maybe right behind the agenda. But in addition to that, Kelly of our office will be emailing to everyone an evaluation form so that you can fill those out, send it back. We really do rely on your input. And the most important thing I can tell you is we're looking for new topics that would interest you. I can tell you that you can save the date. We have 2 dates that we'll be doing these best practice programs. April 15, which is a Thursday afternoon. We'll also have a 3-hour program like now. And we're looking to do a full day program on June 24. So there'll be more information to you in the coming days. Those who will require Illinois credit, please reply to Kelly's email that you are looking for Illinois credit. And for those for Missouri credit, on the Missouri CLE certificate, which is in the materials, probably about page 3, it has the program ID number. So when you're filing for CLE credit, I can also give it to you now. It's ID number 665455, but that's also listed on the certificate in your materials, 665455. Without further ado, Steve Ringkamp, many of you know, and he has been so kind over the years to give of his time and his expertise, a member of the Hulverson Law Firm. His full bio is at the end, and you will be amazed at all the honors and groups that Steve has participated in. This annual review of the law is really a highlight that we've had over the years. And Steve, I want to welcome you back and thank you for participating.
Thank you very much. And thank you all for allowing me to share some thoughts with you about recent developments and an update on the law in civil practice area. I hope you all have your handouts for this. It's 73 pages of synopses of cases for 2020. It covers 540 Southwest 3rd through 601 Southwest 3rd. And a tremendous amount of work goes into this. And frankly, it's more valuable than anything I would have to say because I can only hit some highlights. There's a tremendous amount of law that develops every year. And I want to give credit where credit is due. Joan Lockwood did the lion's share of the work on this summary of the case law. Of course, everybody knows Joan. She's with Gray, Ritter, and Graham. Before I start with the actual handout materials, I'd like to touch on a couple of things. The first is, I'm sure you're all aware of the 2019 Senate Bill 224, which provided for a limit of 25 interrogatories, including all subparts. What you may not be aware of is that if you go read the Missouri Supreme Court rules, this statute has not been adopted by the Missouri Supreme Court rules. West, in a couple of its publications, set forth both versions, both the Supreme Court rule that has no such limitation and the version from Senate Bill 224, which has that 25 interrogatory limit. You may be saying, well, what's going on? I have no answer for you except to say that perhaps two co-equal branches of government have a disagreement. as to who ought to control the rules of civil procedure. That's purely a surmise on my part. But if anybody is interested, Senator Lutkemeyer, who is the author of the original Senate Bill 224, has another bill, Senate Bill 52, currently in the hopper before the legislature. It doesn't really make a lot of additional changes, but it's back for everybody to take a look at and keep track of. The next thing I want to mention to you is that the MAI committee has now published a new 8th edition of the Missouri approved civil jury instructions. Anybody who does extensive work in civil practice already knows that. But what you might not know is that West provides, of course, at additional cost, an ebook containing all of this. So they do not provide the disc anymore that used to be provided with pocket parts and original volumes, where you could actually amend the instruction to fit your case. If you want to do that now, you have to get the ebook. Sorry to tell you that, but the MAI committee has no control over that. That is purely a function of West. But a couple of things that you ought to be aware of that are new in the 8th edition of MAI is that there is a new section of what we refer to as the front matter. The front matter contains how to use this book, how and why to instruct a jury. And those are old sections. The new section in the front matter is a section entitled General Principles of MAI Jury Instructions. And this provides an excellent understanding of Rule 70, of how to make objections, what objections are appropriate, and case law that supports all of this, the discussion in that section. So please, please, please take a look at that new section in the front matter. It will assist you tremendously in providing you with appropriate case law to support your objections and the submissions of your instructions. One of the new instructions that is contained in the book, and many of you may well be aware of it, it is the juror bias or implicit bias instruction. It is MAI 2.00C. What is a bit different about this is that this implicit bias instruction is to be given before voir dire, before jury selection, and it is also to be included as one of the typed instructions that goes back to the jury, typed and numbered, of course, that goes back to the jury for their jury deliberations. So that's a bit different, and it is required in all cases, both before jury selection and during the submission of the case to the jury. Again, before I get to the actual handout materials, there have been a couple of decisions that I want to talk to you about just very briefly out of the Supreme Court. And one that I think is important for you to go take a look at is the Green case. It is 606 Southwest 3rd, 116. And this has to do with summary judgment. It's always important to understand what is required of you in connection with either the allegations that you make in a summary judgment, the statements of uncontested material fact, or how to respond. And the moral of the story with the Green case, and the Green case involved a lady who had her mobile home burned down. She alleged a conspiracy between a neighbor and a couple of workers who did some work and supposedly were paid to burn down her mobile home. She lost everything. Well, she filed a motion for summary judgment, complied with the rules, and set forth what she believed were the uncontested material facts that entitled her to partial summary judgment on liability issues. The defendant argued against it on the basis of some sections of his own deposition that were attached to the motion for summary judgment. Well, but there was no formal response by the defendant. What happened was that the court then entered summary judgment, a partial summary judgment on liability, held a trial on damages, and entered a very substantial verdict against judgment against the defendant. Well, the defendant appealed and said, wait a minute, there were material facts contested as demonstrated in my deposition that was attached to the plaintiff's own motion for partial summary judgment. Supreme Court said, no, sorry. If you want to contest any of the material facts, if you want to set forth why there are still contested material facts, you must, and that's the point, file a response to the motion for summary judgment. The next case that out of the Missouri Supreme Court is a Moore versus Bi-State Development Agency. This was September 15, 2020. For those of you who have any cases against Bi-State, it is SC 98169. Now, the reason that this one becomes important, of course, it is a governmental agency created by a federal compact adopted both in Missouri and Illinois, which, be careful, because the statute of limitations against Bi-State is not a 5-year statute of limitations. It is a 2-year statute of limitations. But that's not the point of this case. The point of this case is that Bi-State, under federal regulations, was required to have $5 million of insurance. Now, the statute on sovereign immunity provides for a waiver in the event that the cause of action either arises out of motor vehicle injuries, or if there is insurance that covers the problem, the injuries. Well, under federal regulations, Bi-State was required to have $5 million in liability insurance to cover its operation. And the plaintiff was trying to argue before the Missouri Supreme Court that that was the limit and the waiver of sovereign immunity up to that limit. The Supreme Court said no, the only limitation on sovereign immunity is that provided under Section 537.610. And so that's the limit that applies in this particular case. All right, so let's move on to the handout materials, and let's start with ADR, Alternative Dispute Resolution. And the biggest issue in these cases, at least that I've had to deal with, has to do with the delegation of issues of arbitrability to the arbitrator as opposed to the court. Well, the first case on page 2 of the handout materials is Fogelsong versus Mockens Auto Group. And there was some fraud going on there. That Auto Group said, hey, this is these cars are factory fresh, brand new. And in fact, they had sustained hail damage. And the seller tried to pass that off. Well, what happened was that the trial court denied the seller motion to stay proceedings and refused to compel arbitration. But the parties in their contract for the sale incorporated AAA rules. And although there was no express delegation to the arbitrator to determine gateway issues, AAA rules do contain such a rule that all issues, including whether it is arbitrable, are delegated to the arbitrator and not to the court. So the case was reversed and remanded, and arbitration required. At the bottom of page 2, you will see Cooper Darcy versus Time Warner Cable. And the importance of this case, this was an age discrimination case under the MHRA. The employer on appeal challenged the trial court denial of arbitration. The arbitration agreement did include a delegation provision for threshold issues of arbitrability to be determined by the arbitrator. The point of this case is you can't just challenge the validity of the arbitration agreement itself. If what you're trying to do is challenge the delegation provision, that must be separately challenged in addition to any challenge that you might have to the arbitration agreement itself. Page 3, the Theroff case. Again, an interesting case. The employee, in the course of her application for a job, supposedly, or at least stated, that she was legally blind and that one of the supervisors assisted her in filling out the forms. One of the forms, of course, was an arbitration agreement. And the plaintiff in this case claimed that nobody read anything to her about an arbitration agreement. She didn't recall any of that. The manager disputed that and also disputed that she never told the manager that she was legally blind or needed any vision assistance at all. Well, in a 4-3 decision, the Missouri Supreme Court affirmed the denial of the motion to arbitrate. And what this says, this case holds as a matter of first impression, is that a delegation of provision within an arbitration agreement included in paperwork is ineffective unless there is clear and unmistakable evidence of the employee's assent to that delegation provision. So note it, remember it, keep it in mind. The next case is Ingram versus Brooke Chateau on page 3. Here, there was a friend who had a general power of attorney for making healthcare decisions for a gentleman who was rendered a quadriplegic. One of the agreements that the power of attorney entered into was a voluntary arbitration agreement on admission to a nursing home. The patient then developed pressure ulcers and brought a lawsuit saying, I didn't sign it. I don't know who signed it, but I want to have my right to trial by jury. The Supreme Court, again in a 4-3 decision, held that the agreement was valid and that the power of attorney, the delegation of authority to make healthcare decisions, implicitly and necessarily carried with it the authority to sign admission documents on his behalf, which included the arbitration provisions. Let's move on to the auto cases, because there are a couple there that I would like to just touch on very briefly. The first is on page 6. It is the Fairbanks decision. And in this case, the trial judge refused to allow the plaintiffs to submit a jury instruction that included as one of the disjunctive submissions following too closely. Went up on appeal, and the Southern District Court of Appeals held that the plaintiff is entitled to choose the plaintiff's own theory of recovery on which to submit the case, as long as there is adequate evidentiary support and the trial judge and the defendant have no say over whether the plaintiff gets a particular submission. It is the plaintiff's option, again, as long as there is evidentiary support. Now, this is the latest in quite a few cases which hold to that effect. But this is something you have to put in to your trial brief so that you get the instruction you want, whether you are a plaintiff or a defendant. The defendant on a comparative fault instruction gets to choose, as long as there is adequate evidentiary support, gets to choose the theory on which comparative fault of the plaintiff is submitted in a comparative fault instruction. I like the Ford versus Skaggs chiropractic case, which is the next case on page 6. The plaintiff, in order to get treatment, was required by the chiropractor to sign a UCC lien that purported to require a lien in the full amount of the charges by the chiropractor. Well, the Court of Appeals said, no, if you have a lien, regardless of what you call it, and regardless of what amount you state in your lien agreement as being required to be paid, if you have a lien at all, you are required, the doctor is required to comply and participate in a division of proceeds under section 430.225, which of course is divide up whatever amount is appropriate under the statute among all the healthcare providers. So again, when you're dealing with someone, before you disperse funds, make sure you get an appropriate lien distribution order under section 430.225. The Capel case, which is next, I want to point out, because this one bothers me, because there was no claim for property damage, and the defendant offered evidence of photographs of the vehicle, which ostensibly, at least arguably, didn't show any damage to the vehicle, and hence made the arguments that no damage to the vehicle, couldn't be any damage to the human. And the plaintiff went up on appeal and said, no, they were not relevant because they were poor quality photographs. Well, the Supreme Court, in response to that argument about relevance, said, no, the poor quality doesn't defeat relevance. It may go to the weight of the authority of the relevance, but note that the issue before the court did not include a challenge on the foundation to the photographs itself, whether they were fair and accurate. The only challenge on appeal was to relevance. Would the decision change if the challenge was to foundation? I don't know. We'll just have to find out on the next case. Page 7, Savage versus Dittrich. This case involved some claims and counterclaims. A truck driver brought a negligence action against a motorist. Motorist filed a counterclaim for motorist's own injuries. The insurance company for the motorist must have settled with the truck driver. And once that happened, that it left only the motorist's counterclaim. Well, the truck driver filed a motion for summary judgment saying, hey, you paid my claim off. There must not be any liability by me to the motorist. And the trial court agreed, granted summary judgment against the motorist in favor of the truck driver. The Eastern District Court of Appeals reversed and said, wait a minute, there are genuine issues of fact to whether there was a contribution to the injuries, to the accident, by the truck driver. Fair to keep a careful lookout whether there was negligence per se. It doesn't really matter. But the issue is that the case should have been submitted to the jury on comparative fault for assessment of each party's fault. This is very clearly required under the Uniform Comparative Fault Act, and I'm not sure how it got past the trial judge and got to the Court of Appeals, but the Court of Appeals did correct the problem. The next case on page 7 is Lockhart versus Carlisle. And this was a case, apparently the only insurance involved was not the driver's or the owner's insurance, but there was a negligent entrustment case against the driver owner's mother. Well, the mother's name was not on the title. The mother did help the son, the driver, the owner, buy the car. And the allegation was that mother should have known that he had no business driving a car because he was habitually reckless. Bottom line on this case is that there is no negligent entrustment theory available under these circumstances. Simply providing the funding necessary to complete a purchase is not negligent entrustment. In order to have a viable negligent entrustment case, the defendant, the mother in this case, must exercise control of the chattel, or at a minimum have the capacity to exercise control over the chattel, the vehicle, either before or during the purported entrustment. Let's move on to civil procedure. And there are a couple of cases in there I want to talk about. Let's move to page 11. The Cupid versus Dry Basement Inc. case in the middle of the page 11 is a Merchandising Practices Act case in which there were allegations, requests for attorney's fees in accordance with the statute, section 407.025. The trial court entered a judgment but did not address the request for attorney's fees. And the holding here is that the court must, it wasn't a final judgment, because if a request for attorney's fees is properly pleaded and pursued at or after trial, the trial court must resolve all issues and dispose of that issue in particular before a judgment is deemed final. Let's move to page 13. I want to talk just briefly about the Cowger case, Cowger versus Murphy, which is at the top of the page. This was a case involving a summary judgment, and what happened was, I see Mr. Brown is taking a picture. Sorry for the interruption. This was a fall on that plaintiff stepped into a hole on some property that was owned by the defendant, but it was leased to third parties. And what this case says is that a landlord, even if there is a reserved right to inspect the property, or that the property had been listed for sale by the owner, that doesn't give rise or an inference that defendants had actual knowledge or control of the premises. Remember, it is the possessor of property which is liable for defective conditions in the property to either invitees or licensees, and not simply a landlord. I'm going to move to page 15. This is a little something you ought to be aware of. This is at the top of the page. It's New LLC versus Bauer. And there was a default judgment. Service was made. A default judgment was entered because there was no response by the defendant. But the summons on which the service of process relied had expired. Now, typically, there's a 30-day limit on a summons, and it had not been extended. It can be extended, or you can request an alias summons, which is simply a new summons that abandons the original summons. But there has to be a valid and effective extant summons on which service is made in order for it to be a valid service of process. So here, the trial court lacked personal jurisdiction to enter a default judgment, and that was reversed and remanded. Let's move to page 16 at the bottom of the page. Fisher versus H&H Motor Group. Used vehicle purchased for $2,200. Problems with defective title, with mechanical issues. In a one-day bench trial, the trial court entered a judgment in favor of the plaintiff for $10,000 or so in actual damages and $32,000 in punitive damages. And that was on July 12. Within 30 days, that version of the judgment was deleted from CaseNet. And on August 6th, the judge entered a new judgment in favor of defendant. Well, he entered the new judgment, nunc pro tunc, which was one of the silliest terms ever invented under the law and ought to be abolished. It, of course, is meant for clerical errors, minor clerical errors, spelling mistakes, that type of thing. But it does not cover, that type of order is not allowed to actually withdraw a prior judgment and enter a new judgment, because here the judgment was exactly the opposite of what had been done in the original judgment. Now, the defendant in whose favor the second judgment was entered tried to say, well, the trial judge sent an email out saying, I'm going to do this, and then did it. The Court of Appeals said, no, you can't do it that way. If you're going to vacate a judgment, first you have to give notice and an opportunity to be heard. If you're going to enter a new judgment, there must be notice and an opportunity to be heard. Note that the appellate court did not reverse and remand for entry of the original judgment, but merely sent the case back to say, trial judge, do it right, give the parties the opportunity to be heard, and do it with proper notice. Let's move to page 19, still civil procedure, kind of the middle of the page. The reason I point this case out is because it involves successor corporation issues. I really don't need to say much about the facts of the case, just that a purchaser, corporate purchaser of a contaminated site that is not a continuation of the previous owner, continuing corporation, it is not the corporate successor, doesn't pick up the liability of the original corporation. However, in this case, it was remanded because there were some allegations regarding cleanup, failure to clean up, and preventing migration of the contamination. So it wasn't a total summary, a total judgment in favor of the new corporate successor, non-successor, in this case. Down at the bottom of the page, I want you to pay attention to State XREL AJKJ, I don't know what that means, versus Hellman. It was a prohibition situation in which the trial court entered a judgment and then vacated a judgment after sustaining a motion to intervene and set aside filed by non-parties in the underlying judgment. The moral of this story is the trial court lacked jurisdiction to rule on the motion to intervene. Under Rule 8105, the judgment became final 30 days after entry, and it didn't really matter if the motion to intervene was filed before or after, because it's not an authorized post-trial motion under Rule 8105. And once the 30 days goes by, even if the motion is on file and awaiting the judge's ruling, it doesn't qualify, and too late. Let's move on to damages. Page 21, Lowe versus Mercy Clinic, East Communities. The only thing I want to point out here is that on periodic payments, section 538.220 requires any schedule of future damages be if there is going to be periodic payment in the case, they have to be in unvarying equal payments. And it's just as simple as that. They cannot vary from year to year or month to month. They have to be unvarying equal payments. And attorney's fees, any lump sum awarded must be sufficient to cover attorney's fees on the entire judgment. Let's move to page 22, the Dixon case, the first full case. All I want to do is point out here that there were some amendments to the Missouri Human Rights Act that purported to and did cap damages and punitive damages in 2017. But that was held to be a substantive change in the law and could not be applied retroactively or retrospectively to a cause of action that accrued prior to those changes. Discovery, page 24. This really bothers me, this type of case, because while the rules of civil procedure clearly provide for a defense medical examination, State Official Hedrick versus Lewis disapproved of the trial court order in the case for an intrusive test, which required injection of dye, fluid, and swallowing fluids. And that's, to me, that's very concerning. Under Rule 61.01, there's no explicit permission for invasive testing, but some courts have been allowing it. But Rule 61.01 expressly provides that specific manner, conditions, and scope of testing must be provided by the trial court's order allowing invasive testing. In this particular case, the Court of Appeals said, wait a minute, that's not a mere technicality. There is a constitutional right to bodily integrity. And if there is going to be invasive testing, the testing must be explicitly set forth and comply in all respects with Rule 61. I'm going to skip employment law altogether because, number one, there's just too much. Number two, it would be a separate 1-hour seminar. So let's skip to evidence. The first case on page 34 is the Watson case versus City of St. Peters. And I point this one out because we need to clearly understand the evidentiary requirements and what the subsequent remedial measures rule prevents. And this case has an excellent discussion of the subsequent remedial measures rule, but note that in this case, the city in question, plaintiff was operating a bicycle and went into a storm water sump that extended onto the sidewalk. And they were aware of this problem throughout their city and had, prior to the plaintiff's injuries, had adopted a remedial program to fix these sidewalks. That's not subsequent. That's prior remedial measures. And even though they didn't get to the particular one in question and may have fixed it afterwards, it's still not subsequent remedial measure because the evidence of previously taken remedial measures or programs to correct problems comes into evidence clearly on the notice issue as to the city. Down at the bottom of page 34 is the Rosales case. And the Rosales case versus Benjamin Equestrian Center, I point this one out to you, not so much because of the equine Activities Liability Act, which purports to immunize equine operators, I guess they are, from liability for inherent risks of horse riding or other activities. Well, here the plaintiff wasn't actually involved in any equine activity. She went in a back gate with a friend, and a horse was being offloaded from a trailer and reared up and fell on the plaintiff. Serious injuries. The defendant wanted to say, hey, we got a sign up that says, pursuant to section 537.325, we're immune, blah, 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 blah. And then the rest of section 537.325. Well, the Court of Appeals said the rule is that questions of law and instructions of law are for the court, not for a jury and not for a sign on somebody's stable. And so since jurors are not permitted to review statutory language, that is a judicial function to both interpret and apply that statutory language in a case when properly requested, the language of the statute itself does not go to the jury. So evidence of the sign, not admissible. Let's move on to page 38. And here we have Ford suing Ford Motor Company. Plaintiff, this again is one of those similar occurrences cases. And this always becomes an issue in product liability cases. It may become an issue in premises liability cases. Here it was a premises liability case against Ford Motor Company that had a pinch point, a crush point between a guardrail and a piece of moving machinery. Plaintiff very seriously injured, very substantial jury verdict, and the plaintiff presented evidence of other persons either being injured at similar pinch points or narrowly escaping injury at the pinch point where plaintiff was crushed. The analysis here is, again, one you need to keep handy for your trial briefs as when you've got this issue, because similar occurrences, the touchstone is the analysis of what is similar, and it is admissible on the issue of notice of a dangerous condition. So put that one in the back of your trial brief, or at least keep it handy. Let's move on to jury instructions. And I want to move to page 42 in the middle of the page. Actually, it's the first full case on that page 42. Miller versus Norfolk Southern Railway. And the case here involves loose cab seats that failed to protect an employee. There was an allegation of negligence. There was also an allegation of negligence per se under the Locomotive Inspection Act. And the trial court refused to allow a jury instruction on the Locomotive Inspection Act, which is federal statute, because there's no MAI. Well, that's not a reason. Just because MAI doesn't provide for a particular theory advanced under a statute or negligence per se doesn't mean you can't submit that theory. In fact, MAI 24.02 for FELA cases does contemplate negligence per se for violations of the Locomotive Inspection Act standards. But the point here is that when you have a case that isn't exactly covered by an MAI, if you've got statutory authority for a theory or a cause of action, you are entitled to submit that theory in an appropriate instruction that translates the language of the statute into MAI type submission. So Again, this is an important case for that purpose. Just because it's not in MAI, if there is statutory or even case law authority for an instruction that is not in MAI, just designate it as such and provide the authority to the trial court for your submission. And of course, what you ought to do is when you do the notation on the dirty copy, you add tendered by plaintiff, tendered by defendant, and instead of an MAI number, you put the statutory number or the case citation. Let's move to page 43, and it's Wagner versus Revocable Trust versus Thompson. I don't know anything about unjust enrichment. What I do know about is allegedly inconsistent theories. And if any of you have the Missouri Bar CLE on jury instructions, it's chapter 70, it's civil procedure is actually the bound volume, but the chapter 70, which I originally authored, and it's been edited and updated by Rob Adams at Shook Hardy Bacon and now Jennifer Artman. And Jennifer is the one who is responsible for that summary of jury instructions, that new section that I pointed out in the 8th edition. She's now the reporter on the MAI committee, and she did a great job on that section. Inconsistent theories may be submitted, and there are numerous cases which allow that to happen. Now, plaintiff can't recover on both theories, but the classic example is, hey, I'm involved in an auto accident and I don't know who's driving. I don't know if it's dad or son, mother or daughter. I don't know which one was driving. I want to submit against both of them. Trial judge may say, no, you've got to elect because that's inconsistent. No, there is no election required at that point. Now, a jury can't come back and say they were both driving because that clearly would be inconsistent. But they do get to choose which theory. If the theories are indeed inconsistent, the jury gets to choose which theory of recovery is appropriate, if at all. And of course, in your closing argument, you need to tell the jury about all of that. So what this Wagner case stands for is, number one, inconsistent theories may be submitted to a jury, but number two, follow Rule 70 when it comes to objections. If there is a claim of instructional error, a specific objection, not a general objection that it's not supported by substantial evidence, that's general. You must make a specific objection during the instruction conference. You must then raise the identical objection in the motion for new trial. And you must raise on appeal the identical objection. If at any of those stages, your motion for new trial changes your idea of what was wrong with the instruction, too bad. If you didn't make that objection in the instruction conference, if you change your idea of what was wrong with the instruction up on appeal, too bad. It's got to be consistent under Rule 70.03, and those instructions must be timely and made during the instruction conference so that if there is a problem with the instruction, the trial court has an opportunity to correct that error. Okay, let's move to jurisdiction and venue. Page 52. The case at the bottom of page 52 is a forum non-convenience case. Now, you know there is no intra-state forum non-convenience. It's for the doctrine only applies to send a case out of the state of Missouri. Well, you only can send a case out of the state of Missouri to a more convenient forum if that forum is available for a full and complete recovery. In this case, the injury that was alleged was a freight train and a bus collision. The injury that was alleged was not barred by Missouri statute of limitations, but was barred under the Mexico statute of limitations. And since the collision took place in Mexico, that was the reason the defendant said, hey, kick it out of Missouri and send it down to Mexico. Well, there was no forum available because of the expiration of the statute of limitations in Mexico. Hence, the doctrine of forum nonconveniens would not apply. Let's move to page 54 and the case of State XREL Key Insurance versus Roldan. Excuse me, we're running out of time?
About 2 minutes.
Well, why don't we open it up for questions if anybody's got any questions? Look, there are a lot of cases here. Take your time, go through this. It really is extraordinarily well done. And again, most of the credit goes to Joan Lockwood at Gray Ritter Graham.
Steve, I don't see that we have anything in the chat. And I'm wondering if someone has a particular question, could they email you?
Of course.
Okay. Okay.
By the way, Rob, I do want to add that the Missouri Bar next Tuesday is having a seminar on the new edition, 8th edition of MAI. Joan Lockwood, Jennifer Artman, myself, and Lou Leonati, who's a farmer member, are all participating in that Missouri Bar seminar.
Outstanding. That's great. Steve, I want to thank you again. You've been so generous of your time, your expertise over the years, and this particular version of what you and Joan put together is really terrific, and we thank you.
Oh, you're all quite welcome.
Very good. Folks, another reminder that I was remiss earlier in mentioning is proceeds of our program today, as with all of our best practices programs, are donated to particular charities. And this program, we're splitting the proceeds between Legal Services of Eastern Missouri and the Kornblum Food Pantry. Both are filling needs during this pandemic more than ever. And we thank you for attending, and it's a proud moment that we can pass on proceeds to these organizations. Why don't we take just a couple of minutes, and then we will switch up and get Chris Stegemeyer all lined up. Thank you.
Rob, am I being heard?
Yes.
Great.
I hear you. I
Super
see
duper.
you. I have put you as a co-host so that you can share your screen,
Alrighty.
and you should be able to.
How about that?
There it is.
Okay. I'm just gonna play with it a little bit, make sure. Yes, it actually seems to be operating as advertised.
Great. Great. And Chris, thank you again for doing this.
You're very welcome. Thanks for thinking of us.
Well, we've been fluctuating between 90 and 97 attendees, and
Well, I'll chase those out of here in no time.
well, it's not rocket science. So we put the ethics at the end, so folks do have to stick around. And are you flying solo, or is Whitney joining you?
I'm it.
Okay, very
I'm
good.
it. Yes.
Very good.
Whitney is dealing with, not dealing with, she's participating with the ABA Young Lawyers Division stuff all afternoon. They've got a full slate of not activities, but meetings and committees and so forth that she's involved with.
Very good. Very good.
Ought to be a young lawyer, right?
Well, yes and no. Okay. Why don't we give it just about 2 more minutes?
Okay.
And and then we'll get started.
Just, and I don't mean to be persnickety, but it has to be 50 minutes. So,
Yep.
okay, just, that's not my rule.
Nope.
I like to
Nope.
remind everyone
Nope.
or have them reminded.
Okay. Okay. Well, why don't we go ahead and get started?
Very well.
Folks, Chris Stegmeyer is the Director of Risk Management with the Bar Plan. Is another individual who has been giving over and over of his time and experience to talk about ethics, professional responsibility issues, malpractice prevention at our best practice seminar. And we had chatted about issues that relate to our obligations as lawyers and challenges that we have in the midst of a pandemic and dealing with COVID-19. Chris, thank you so much for participating today. We look forward to your program.
Thank you very much. Well, let's dive right in with what I'll be talking about, a brief overview just to let you know what's coming. We're going to be talking about some ethics issues regarding the unauthorized practice of law, different confidentiality and potential security issues, client communication and diligence and supervisory duties in a COVID type environment, different stress and well-being issues and how they can affect lawyers and lawyers' clients, succession planning, practicing law in an uncertain economy, and different resources that may be available beyond simply this program then as well. I want to start off with the idea of unauthorized practice of law in a COVID environment, because if you're like me, then you are doing most of your work now from home. I will tell you that I'm in the office right now. I'm in our offices right now. We generally have probably no more than maybe 5 to 10 of our 35 employees in here on any given day, because we were extraordinarily fortunate in that we had actually been just serendipitously planning for the idea actually from a disaster planning perspective of having to work remotely. And so when this disaster occurred, we were ready to go remote very seamlessly. So hopefully that particular issue worked well for you. I'll be talking about some particular items to be aware of or issues to be aware of later on with the idea of working remotely. But a big one, of course, right now is the idea that you may be possibly engaging in the unauthorized practice of law if you're working remotely, particularly if you're working remotely from another state. And here I would assume a simple example would be you're licensed in Missouri, only in Missouri, but you reside in Illinois. And you have gone home because your office is working remotely and you are remotely practicing law while in Illinois, or perhaps the other way around. Let's say you're only licensed in Illinois, but you live in Missouri, and now you're sitting here in Missouri, and you're doing all these things for your Illinois clients. Well, there are rules on this. In Missouri, the unauthorized practice rule is 4-5.5. For example, in Illinois, it will be a 5.5 variation of whatever Illinois has. And whenever I talk about UPL issues, one of the things that I stress is that the rule that you want to be looking at is not the rule where you're licensed, because that's not a problem. You want to be looking at the rule and the law and the statute or opinions, as we'll see here in a moment, in the state where you're sitting. You know, where your butt is sitting is going to determine which rule is going to apply in the circumstances, and they may be different from jurisdiction to jurisdiction, obviously. So 4-5.5A in Missouri states that a lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction or assist another in doing so. And now we're off to the races, right? Well, one of the races that was being raced with this question is from the ABA, where they recently issued their formal opinion 495 regarding lawyers working remotely. And it states first that if a particular jurisdiction has made the determination by statute, rule, case law, or opinion, that would be an ethics opinion, that a lawyer working remotely while physically located in that jurisdiction constitutes the unauthorized or unlicensed practice of law, then Model Rule 5.5A also would prohibit the lawyer from doing so. Well, keep in mind, that's the model rule that is being referred to in this formal opinion because that's all they can refer to. I did not do a comparison between model in Missouri or model in Illinois or whatever, because that's just a rabbit hole you can go down forever. But what I would recommend is that if you have concerns about this particular issue, is do that. Hold the model rule and whatever rule in the jurisdiction where you're sitting and practicing remotely, hold them up side by side and see what they look like. And chances are they're going to be pretty much the same, because the UPL rule is one of those that hasn't been tinkered with a lot from state to state to state. So likely it is very similar to the model rule. But first of all, the issue is what does the particular jurisdiction in which you're residing say or conclude about the question of unauthorized practice of law? Well, lo and behold, there is from 2003 a Missouri informal ethics opinion. The question is a lawyer licensed in Illinois and attempting to become licensed in Missouri. The attorney's office is located in Missouri. You'll see that's bold and underlined for a reason. Can attorney, by me, this is emphasis added, can attorney practice Illinois law from the office in Missouri? And the answer is no. The attorney may not engage in conduct that constitutes the practice of law while physically located in Missouri. So we have right there what in part I think the ABA formal opinion was getting to in terms of the Missouri informal opinion regarding a different conclusion as to how the rule is going to be implemented. But remember, I added some emphasis there on the word office. The Missouri rule goes on to state under its paragraph B, a lawyer not admitted to practice in this jurisdiction shall not, except as authorized by this rule 4, blah, don't worry about it, or other law, establish an office or other systematic and continuous presence in this jurisdiction for the practice of law, or hold out to the public or otherwise represent that the lawyer is admitted to practice law in this jurisdiction. All right. Well, now we're going to get down into what the meaning of several different things means, right? The ABA opinion that I just mentioned says that absent that determination that I mentioned on the previous slide regarding the case law, the statute, or the whatever, making a determination that remotely practicing is UPL, this committee's opinion is that a lawyer may practice law pursuant to the jurisdictions in which the lawyer is licensed, that would be the licensing jurisdiction, even from a physical location where the lawyer is not licensed under specific parameters. So what does that mean practically? In other words, the lawyer may practice from home or other remote location, whatever laws the lawyer is authorized to practice by the lawyer's licensing jurisdiction, as they would from their office in the licensing jurisdiction. So we're starting to see what the ABA opinion did was it started to parse through the meaning of location as opposed to office. Let me back up here a little bit on this slide regarding office and the Missouri formal opinion. First of all, it comes from 2003, and so the idea of working remotely, it was one of those things that probably pretty far out on the horizon of consideration. And oftentimes, the opinion itself is the response to the question that forms the opinion or the conclusion is going to be driven by the language used in the question itself. And you'll see that the question is asked, attorney's office is located in Missouri, not the attorney's home, but the attorney's office. And so that led to the conclusion that you see there in answer 1. You know, I'll give you another example of this. For literally decades, lawyers would tell me that they were in an office of counsel relationship. And because they were in an of counsel relationship, they could do X, Y, Z, or they didn't have to do A, B, C under the rules. And then they would describe to me what their of counsel relationship was. And I would say, well, that's not an of counsel relationship. You can call it that, but that's not what it is. This went on for decades. And then I would get, you know, this kind of pushback where lawyers would say, well, I asked maybe OCDC, or I asked the Legal Ethics Counsel's office, and they said if I was in an of counsel relationship, which I say I am, then I can do or not do whatever it is I'm saying I do or don't have to do. Then it's permissible. Well, one of the problems with that approach is that the description of counsel always presumes an answer. That is, it leads to a particular kind of answer. But what happens if you're really not in an of counsel relationship? Then it's a totally different answer, right? And so when lawyers would ask the question would be, I'm in an of counsel relationship with another lawyer, law firm, whatever, and the ethics authorities would say, okay, we'll take you at your word. We will take you at your word that you know what you're talking about. And lawyers don't know what they're talking about when it comes to what does it mean to be in an of counsel relationship. They just think slapping the label on it was enough. For literally decades. And I know this because I've been doing this for literally decades. And then last year, somebody was asking some questions about an of counsel relationship, and the Legal Ethics Counsel's office said, if you don't do this, you can call yourself of counsel until the cows come home, but it's not of counsel. In other words, it set out the parameters that have to be met in order for it to be a legitimate of counsel relationship for consideration under the rules of professional conduct. And I think here, once again, you know, we're seeing an answer that's being in part dictated by the language used by the asking lawyer in the question. So now we fast forward and we're getting into this remote working environment, and the ABA opinion and the former Missouri informal opinion, not the former one, but the Missouri informal opinion, the earlier one. So ABA Formal Opinion 495 goes on to say that a local office is not established within the meaning of the rule by the lawyer working in the local jurisdiction if the lawyer does not hold out to the public an address in the local jurisdiction as an office, and a local jurisdiction address does not appear on letterhead, business cards, websites, or other indicia of a lawyer's presence. So there's no holding out that the lawyer has established an office. Are you kind of seeing how this ought to start to be played out from the perspective of a lawyer working remotely in another jurisdiction? Likewise, it does not establish a systematic and continuous presence in the jurisdiction for the practice of law, since the lawyer is neither practicing the law of the local jurisdiction nor holding out the availability to do so. And along the there's some language in there about the lawyer's physical presence in the local jurisdiction is incidental. It is not for the practice of law in the jurisdiction. And so in this, the example I used earlier of the lawyer that licensed in Missouri, clients are in Missouri, but they're sitting in their kitchen in Illinois to represent them. That's where they are is incidental to the nature of the practice. Now,
Chris, could I ask you a question about that?
Sure.
So one of our attendees has the question of what happens when you're on vacation, you're in a state that you are not licensed, and can you do client work while you're on vacation? So I'd ask that as question one.
Okay.
Question two is, what happens if you really like the locale where you're on vacation, and then the next year you said, you know what, the heck with St. Louis winters, I'm going to go to Scottsdale for the winter, and you're going to service your clients from Scottsdale via Zoom and email. Um, Can you do those things? And is there a difference between the two, being gone for a week or being gone for 6 months?
Well, let's get into this a little further. Maybe that'll answer partly, and then I'll give you my final answer
Great.
based on that. But thank you for that, because yes, I was anticipating those or something similar would come up. So comment 6 inside the rule which you see actually right there in Missouri, it's comment for C5, but there is no single definition for what is temporary, and that may include services that are provided on a recurring basis or for an extended period of time. And for example, in a pandemic that results in safety measures, regardless of whether the safety measures are governmentally mandated, so that means it can be employer driven, that include physical closure or limited use of law offices, lawyers may temporarily be working remotely. How long that temporary period lasts could vary significantly based on the need to address the pandemic. So let me do a little bit further. So one of the things that's interesting here in the conclusion of this opinion is that you see there in the first paragraph on the screen, the sentence that concludes, if the lawyer is for all intents and purposes invisible as a lawyer to a local jurisdiction where the lawyer is physically located but not licensed, then it's not a violation of the rule. So you want to remain invisible in the absence of the local jurisdiction's finding, and that can be important as well. So I don't know what Arizona is going to say about this. Arizona is going to have their rule, and I doubt quite seriously, because Arizona wants people from Missouri being fed up with the winters and coming to Arizona and spending, all the rich attorneys are going to come down there and spend gobs of money in Arizona. They would like that kind of thing. There are, in fact, Rob, some ethics opinions from other states and court decisions where lawyers have been charged with the violation of the unauthorized practice of law in a particular state. And several state Supreme Courts have said, why do we care if a Missouri lawyer is going to come to Arizona, sit on their computer, and represent Missouri clients with Missouri law problems and do it from Scottsdale? And the answer is, these courts have said, we don't care about that. What we care about is if the lawyer from St. Louis comes to Scottsdale and starts to hold out in the community of Scottsdale or Arizona that I am now accepting Arizona clients even though I'm not licensed here. I have an office in Arizona and I could even see where, there are going to be potentially some questions, even if the lawyer holds out to the Missouri clients that, I'm now in my office in Scottsdale. That's going to raise some red flags if anybody sees it, and it's going to start possibly generating inquiries about, why are you establishing an office in Arizona? And then the comeback is going to be, oops, my bad. It wasn't an office, it's my summer home or my winter home or my vacation home or my whatever. So I think this idea of invisibility to the local jurisdiction under the ABA opinion can be very critical in terms of what the lawyers may do in Arizona, Florida, Colorado. It seems like every lawyer I know has a place in Colorado, and they want to go where it's colder. Go figure, because there's snow and mountains you can fall down on while you're presumably skiing. So that, like I said, that invisibility factor becomes an issue. And I think as the rules always are looking to catch up to the technology. It's seldom that the rules are going to be out in front of the technology. And as this becomes more and more common for lawyers to leave or to actually abide or have an abode in two places, I think that this kind of a result is going to become more and more common. Now, having said, that's an opinion because it's reality, and the rules can't bust up reality too much. But having said that, there is still in Missouri that informal ethics opinion. And so if if you want to switch my example around, and if you want to go from Illinois and do it in Missouri, you're going to sit, your house is in Missouri, and you're going to work from your kitchen table for Illinois clients with Illinois law. It would be very appropriate to ask the Legal Ethics Counsel's Office, in light of that 2003 opinion, what's the difference between establishing an office in Missouri and working remotely for Illinois clients while in Missouri? That's a distinction, and I think this ABA opinion would lead it, and I think the answer would be, we don't care. Ultimately, like other jurisdictions have ruled, but it's still sitting out there, and I think that it could create difficulties for an attorney who wanted to go that route, come back in, or other jurisdictions that may have similar types of opinions that go back in time and place in a way that the issue of remote work really wasn't even considered. It was, you were all, wherever you were, that's what you practiced, more or less. And of course, all the rules are local, or for the local jurisdiction. And the ABA opinion can be instructive. And here's the other thing about the ABA opinion, if you're in this situation, is that it can help lead the question. I can't ask the question because they wouldn't answer it from the Legal Ethics Counsel's Office, but the lawyer that's in the circumstance or the situation ought to read this opinion, make those distinctions, and then ask the question in a way to lead to the answer that they want, by making the distinction already on behalf or for, or don't ask Legal Ethics Counsel's Office to find the distinction that you're looking for, present it to them. Because, I think this is an appropriate outcome. There are a lot of opinions that do give me heartburn because I think it leaves lawyers in a lot of gray areas. This ABA opinion is one of them. It's just a nod to reality. But there is that other one out there, and I think that ought to be clarified if you're going to work in any particular jurisdiction that maybe had that sort of an approach.
Great, thank you.
Anyone else? I'm always happy to try to answer questions. I do want everybody to know that my opinions are worthless. So all it is maybe a place to work or start getting going, right, on the question itself. As I always say, you can't rely on anything I say here today, anything at all. So one of the things that comes up with working remotely is the idea of confidentiality of information. And the issue of confidentiality becomes, I think, really balled up with misconceptions over ideas of secrecy. I have had, I wrote an article earlier this year about a judge in Florida who sent out a memo to all the attorneys in the whatever county that he worked in, that he judged in, and said, since we're going to be having these remote hearings, for example, on all of our family law cases and so forth, I would really appreciate it if, and these are just some general manners rules, I would really appreciate it if the lawyers would not show up in their nightgowns while in bed. That was one example. Or poolside with the swimsuit on and the pool in the background and so forth. Not that the judge has anything against nightgowns or swimming. It's just that for purposes of these kinds of hearings, let's show a little bit more respect for the court and so forth, if nothing else. But one of the other issues that does come up in these circumstances is the idea of confidentiality. And I actually raised that as part of this article, and I get, it's the constant pushback. How can it be confidential if it's a hearing in public, in open court? And the only difference is that instead of being in court, now I'm working remotely from Illinois or Missouri, whatever. And so who cares if the cabana boy overhears this? Confidentiality is not an issue because it's an open public hearing. There's no, well, here's the little trick about confidentiality. Yes, it is. Yes, it is. And it's the lawyer's duty to make sure that that hearing cannot be heard because The lawyer's duty is to make sure it remains confidential. Now, I get that you may have a hearing in open court where there may be a room full of lawyers and other parties and so forth, and you're having your hearing up there and they would be able to hear it. I would also point out that in many of those cases, a lawyer would have a duty to make sure that these hearings were held in a manner that did protect confidentiality. But nevertheless, there's no, as you see right there on the bottom, there's no public records exception for the lawyer's duty of confidentiality. Another thing that I do hear about confidentiality all the time is that, well, the client waived confidentiality. And that is nonsense on stilts. I mean, that's just taking stupid higher and farther because there is no waiver of confidentiality. There can be no waiver of confidentiality by the client. Why? Because it's the lawyer's duty. It isn't the client's right or anything. It's the lawyer's duty. And so the only way confidential information can be revealed is with either the consent of the client or some other exception to rule in Missouri 4-1.6. That's it. If the client goes out and tells all of their legal secrets or spreads all of their information about the case all over social media, there's not a waiver of confidentiality. Maybe a waiver of privilege, but not confidentiality. So it's really important to get those concepts correct and know that even working remotely, you need to protect your client's confidential information in the setting in which you're participating in these remote court hearings, maybe trials or whatever. So get someplace where you can close the door, make sure, moving forward here, make sure things such as client files and so forth are not just sitting out. One of the things I think that's very important in the circumstances of working remotely, especially if you have an office, not an office for purposes of UPL, but a place you go in your home that you call your office, or you're working off your kitchen table, whatever, is that you need to train and educate the people that are going to be in the home with you, from spouses to children to maybe cleaning personnel that you utilize in your home, whatever. Tell them, look, I'm a lawyer. This is very personal and private stuff that is in these files. If you happen to see one laying about, first of all, avert your gaze and then come and tell me that it's laying out somewhere. But don't start looking through it. And I had this talk with my own kids when we started to work remotely. I said, if I have my screen up and I leave the room because I want to refill my coffee, don't come wandering in here and start looking at my screen, even if there's nothing on it to be seen. Well, a few months later, one of my kids, I walk in and they're looking at my screen. Now, there wasn't anything to be seen, but it's a constant reminder. This is all stuff that we have a duty of confidentiality to. And so part of that is we have to train the people around us as well. Don't take, please don't take advantage of my mistake or my error or my oversight in how I may be treating any particular item of confidential information in any particular moment. And because you never know, I can tell you confidentiality stories that go back 20 years about the horrors of lawyers who hadn't thought this through far enough in any particular situation and what befell them afterward. So certainly one of the issues of working remotely is I would recommend either having an extraordinarily high level of trust in the people that reside with you, and having kids. I don't think there's any such thing as a high level of trust on this. Not that I don't trust my children in a lot of different ways, but lock up, you have to have a place where you can lock up the files so that they're not accessible no matter what the circumstances are. So keep those issues in mind as you go about setting up that work remotely kind of circumstance in your environment. Let's see. video court hearings where the attorney plans to testify as an expert witness, may attorney answer question about attorney's prior representation of a client where attorney was ordered by a court in the previous case to testify about confidential information was ordered by the court, and where attorney's testimony in the present matter would be similar to the testimony now contained in the public record. So the answer basically is no. It's confident that even though it was the lawyer's testimony in a prior case, I mean, I'm so happy that the lawyer thought to ask the question, because once again, a lot of lawyers are going to think, this is my testimony from a prior case I was involved in. Surely it can't be confidential now. Well, don't call me Shirley, and yes, it's still confidential. So there is no, that public records exception is simply, it's a myth idea. Now, under 4-1.9, and I think that's oftentimes where this myth comes from, there is a possibility of getting into a representation adverse to a former client, depending on the nature of confidential information in the representation. And one of the ways to examine that question or analyze that question is whether or not the confidential information is generally known. And the issue there then becomes what equals generally known. And it's a very high bar to shove confidential information into the generally known category. It's a big rock, you're pushing up a steep hill. It isn't just, oh, it shows up in the public record somewhere. That ain't it. It's sort of one of those circumstances where if you stop 8 out of 10 people on the street, not only do they prefer Folgers, but they know about this particular case and all of the facts that you want to reveal about it. So, that generally known, even under 4-1.9 is a pretty high bar. And under 4-1.6, it just isn't there at all. So there you go.
Chris?
Yes.
One question dealing with confidentiality. It used to be that all of us had an office phone line, and today, since many are not in the office and we're sitting there living with our cell phones, what happens when you take a client call? You're in your car, you have a spouse, you have kids in the car. What do you recommend? Is it, I can't take the call right now? Or so that you can only take the call when you're alone? It's kind of a different universe these days.
Yes, it is. And I think maybe it goes back to a trust issue. Do you trust your kids to have the earphones in and not hear at least one half of the conversation? But two, I recommend from a risk management perspective that in those situations, you explain to the client first, is this something that can wait for the 10 or the 15 or the 20 minutes for me to get to a location where I can protect your information as appropriate? In other words, this isn't my convenience, it's to make sure the client is being protected. I do think that's entirely appropriate, and because you never know where the spouse, the kids, or whoever else is in the car is just going to overhear some random thing, and all of a sudden, everybody at your daughter's 9th grade soccer team practice knows what's going on with a particular client. And that example doesn't come flying out of nowhere, because that's eventually what happened in one of those horror stories of information not being held closely enough, the confidential information. I would recommend doing that. And I think it's also, and because of that, because the environment in which we live and the technology that we have, as part of the intake procedure, I think it's really appropriate to have a conversation with the client on both ends of that. If I call you or you call me, and we are not in an environment where we can talk with a reasonable degree of expectation that our confidentiality is going to be protected, we both have to recognize it may be necessary to move away hold on for a minute or set up a time when I can call you 10 minutes now, or if that doesn't work, an hour and a half from now, and then follow up appropriately at that point. So that you take the sting out of that insult. Well, they don't want to talk to me now because they're, first of all, I guess if we're driving, none of us should be on the phone anyway, right? That's a safety issue. And I can tell you that at the bar plan, it's one of the things that we're not permitted to do as employees when we're on business. And so take that off the table in terms of any kind of an issue by having the conversation beforehand. And it's really good, I think, to have that conversation with the client because they can do things unknowingly if they're not properly educated by the lawyer whose job it is to educate them. Waive privilege if, for example, they put their phone on speaker while you're talking to them, and because they want a parent or a spouse or an adult child or whatever to hear the conversation along with them. And then that raises all, it's just, Rob, when you and I started, it was the old deal of we have to explain if they want the spouse in the room while we're talking about their car accident, privilege issues and so forth. Well, that conversation still needs to be had. It's just that the technology changes the possibility for the lawyer to not even know what's going on because they won't see the individual necessarily. We do always hear, well, probably you can always tell when you go on the speakerphone, and there's a red flag then as well. Am I on speakerphone? Is there anybody else around? I talk to almost everyone on speakerphone now just because it's easier to take notes and so forth. It's just easier, but the door is shut. And that's just the reality in terms of using the technology, I think. One more lesson in the technology.
Yeah, the same thing with the Zoom call. You can see the person that you're talking to, but you cannot see behind the camera.
Right.
And I know when we're mediating by Zoom, we're always asking the question, is there anyone else in the room with you?
And always ask if you're being recorded.
Yep.
And did I get to this question or not? Cybersecurity. If I did, I'll skip over to when I get to the slide. But one of the questions, I know that I did put a slide in here. Recording your client in Zoom, and then certainly recording other individuals in a Zoom phone call. So some other issues about attorneys and employees, and obviously, hopefully by now, all of these things have basically been accomplished. The security of the system, and the networks and so forth that are being utilized, the firewalls and the virus blockers. Once again, I'm really, really lucky because we have an IT department here, and they work assiduously to make sure we have these things in place as we are working. A lot of you may be do-it-yourselfers, and so it could be one of those situations that has to get bumped up. One of the things I talked about last year's seminar was the idea of enterprise risk management. And this may be one of those blocks under an enterprise risk management plan that goes from the green or the goldenrod up to the red in terms of making sure that you are addressing the issue appropriately and timely from just a network security standpoint. The multi-factor authentication. And then you also have to deal with a situation of, you take it to the next step, which is, if I'm using my phone for multi-factor authentication and I lose my phone, how do I authenticate the device I'm using to try to find my phone? Well, there's another step to that process that you can take, if that's the situation. Once again, I'm kind of lucky in that regard, because if that happened to me, I would get to my IT people and they would make it all good. If you may not have that as an option. Make sure, just like in the old days, you kept an inventory about who had keys to the office, and now everybody has swipe cards or whatever, buttons to push in. Now you have to inventory your laptops, the phones, and the devices, and you have to make sure those are coming back in. You have to start keeping track of all of those as well, and then obviously the appropriate backup procedures. And an appropriate backup procedure is one that makes sure you have your data. Anything that doesn't accomplish that is inappropriate. What's the technical aspects of doing that? I haven't the slightest idea what yours are, but appropriate means it's accessible and it's clean. And recognizing now that, you know, most of the bugs that are going to be infecting your data are going to be in there for a time, so that there also will have already infected your backups without you even knowing it was in there yet, because they haven't been activated. So congratulations on that. But anyway, still, backup is king in terms of protecting the data and making sure that they can then be downloaded in the future. So some other things that have come up recently are phishing scams. I've read a couple of stories recently about lawyers whose staff have been fooled by the phishing scam that it's going to be something that it will look like it comes from client or adverse counsel in a matter, and it's going to have an attachment to be opened. If there's anything that makes you question the validity of it, it doesn't sound right, it doesn't look right. You know, maybe the lawyer at the other side always has their firm logo at the bottom, and this one doesn't, but it does have an attachment. Anything, then you delete it and follow up with a phone call. Did you send me this? Because if you did, you have to send it again. But I've already deleted it. Don't even leave it hanging out there for anybody else to see, and don't spread it around. Don't start, sending it from person to person in the office saying, did you ask for so-and-so to send this to you? It's better to have to get it again if you've deleted it incorrectly than wonder, well, I think this is okay, let me see just to make sure. And it's becoming, there are people who are all the time trying to get into your client's data. And I know that a lot of lawyers say, well, they're never going to find out anything. Do you have a single social security number about anybody in all of your data? That's all they need. That now makes it valuable for them to get into your data. A home address, a phone number, all of those, all that kind of stuff. They don't care about the particulars of your case. They're not trying to blackmail your clients. They're just trying to set up the false identity, sell the numbers on the black web, dark net, whatever. That's all they're trying to do. That's all that they want. And so invariably, some of that information is always going to be in your, and then then you get into the whole, oh, now I have to tell my client, now I have to report everybody, that I'm holding personally identifiable information for, and not just on your clients, but everybody. So, the example I use to illustrate that is, we have a firm we insure that in collections work. They have about 3 clients. They have data on literally tens of thousands of people that they have collected accounts for, or, the debtors. They have that data in their system. If they get hacked, their duty is not to notify the 3 clients. I mean, ethically, they have to notify the 3 clients, but under the law, they have to notify those tens of thousands of debtors, because that's the personally identifiable information. The law does not make a distinction from client to non-client. It just makes a distinction of, do you hold the data? Let's see. The phishing scams, stuff from Small Business Administration. Just, think about what's popular in the day. What is an issue that's popular in the day, and right there, phishing scams are starting to go out about whatever it may happen to be. So here you see Small Business Administration, disaster relief, and so forth. There might be something coming up that, somebody's going to have a ribbon for, or something else in another 3 months, and that'll be the phishing scam. Obviously, anytime, every time there's a disaster, there are Facebook or GoFundMe sites that are set up, and those are unfortunately set up oftentimes by people who want the money, saying that it's going to go to the victims of whatever, and it doesn't. And so those have to be vetted appropriately as well. Now, that's just from being scammed and losing money kind of an approach. But the idea more particularly is, if there's an attachment to them and they've written inside your system, then it can be devastating for the law firm. So then that article I read that you saw on the previous screen put out these sorts of, oh, be careful about this sort of stuff in terms of your protection against those phishing attempts. So client communication. This is, let me just get into, here we go. Formal opinion from Missouri 123. And this is an actual formal opinion as opposed to an informal opinion, which means it's binding on all Missouri attorneys. If a recording of a conversation with a current client, the attorney must give some notice to the client the attorney is or may be recording the conversation. Giving this notice is necessary under the attorney's duty to communicate with the client and is consistent with the attorney's duty of loyalty to the client. So there are ethics obligations that go on. And one of the things that's interesting with this is a recorded Zoom conversation is part of the file. So if you 2 years later now get to the conclusion of the representation and your client asks for the file, that Zoom conversation has to be sent to the client as well. It's just like like anything else that gets recorded or notes in the file and so forth. It becomes part of the file. And so before a lawyer were to start doing that, one of the considerations is, how are we going to reproduce this when one, how are we going to maintain it, and two, how are we going to reproduce it? And there are limitations oftentimes on how much data can be stored or maintained, especially with these video files, which can oftentimes be rather large. And so you may have to work with some of those issues inside your technological capabilities at the firm. Nope, right there. It must be true because I said it at the bottom of that screen. Let's see, what else do we have? Oh, any sort of video, as Rob was saying, all meeting participants close all of the unnecessary applications, the files and browser tabs prior to entering the meeting, so it doesn't inadvertently get shared. If you're going to do this Zoom stuff, you might want to have a little tutorial with your client to make sure they're hitting the correct buttons and not opening things up before you go live with one of these. Have a sample Zoom meeting to make sure that you know and you're comfortable that they understand the technology. If you recall, when emailing became a big thing, there were all sorts of ethics opinions about the use of email and warning the client, so forth and so on. And one of those ethics opinions actually led to the stupidity in Missouri known as the required email disclaimer. There's no requirement in Missouri to have an email disclaimer on the parts of lawyers when they communicate with their client or anybody else. It is not an ethics requirement in any way, shape, or form. And in fact, I think it does more harm than good because quite honestly, the lawyer's duty to the client is to educate the client about and get their informed consent about the use of email, not tack on some stupid boilerplate, unnecessary, and completely worthless disclaimer on every email that they send out. But now, fast forward that email situation, which a lot of lawyers I know got really, really concerned about because it elicited a lot of informal opinions in Missouri and elsewhere, and that is the complete crickets heard when lawyers are using this video conferencing technology and issues of storage and accessibility and who may be able to get to it besides me, and what are you warning the client about, and how comfortable are you that the client knows how to use it appropriately. And so all of those kinds of issues with that technology need to be run through, and the assumption that anybody knows how to use it is a dangerous one for the lawyer to take on. The notifications idea and the pop-ups and everything, all those ought to be turned off and put into the background. The first sentence there in that second paragraph is you need to know, and there ought to be a list that is maintained in the file of everybody that participated and was permitted to participate, so that, like Rob said, who's behind the screen, That ought to be asked. Is the client here, and is the doctor here, the other lawyer here, whatever the list is, that's a document that ought to be maintained a lot, so that there's a log basically of who was supposed to be there, and the fact that you checked it, that you did your due diligence in attempting to protect these. Once again, the information and privilege, for example. And then one of the things that I will tell you that our IT people are really, really big about here is that the meeting gets locked once everyone is in, that it just doesn't stay open, because it's possible for hackers to be able to jump onto a link feed and get into it with the lawyer not recognizing that they're necessarily coming in, because the lawyer's operating the actual meeting itself. So you ought to have the capability of locking it down once everybody's in. Nobody else is permitted to get in. And there can be a knock at the virtual door, and then once you know who it is, you can let them in, but not otherwise. So let's see. I know that I'm kind of running up on my time, and I put a lot of information in here that I wouldn't necessarily get to in the time allotted for this hour. I hope that what you did here was valuable to you. And I know that with Steve in the last hour, I do want to hold out. If I can be of any help, if you have any questions on some of these things, my email address is castigameier@thebarplan.com, and you can email me your question, and I'd be more than happy to follow up with it to the best of my ability in the circumstances. Now, just some other items, and then we'll wrap up here in just a minute or so. First of all, the idea of diligence. It pays to make sure that you are staying on course with your client communications, and that may require some sort of a set schedule sometimes, because you're getting out of the habit because you're not in the office anymore. Your supervisory duties, some of this stuff may change on the supervisory standpoint with your employees. One employee may have been really, really good in the office, and you didn't have to watch them so much, and you take them out of that office environment, and you put them out working remotely, and it could change. And you need to be cognizant of that and aware of that, so that you can respond to an employee that may need new, different, or increased supervision because of that remote environment. I think succession planning is an important one in these circumstances. And just very briefly, well, there's a whole 2020 informal opinion on the prospect of succession planning in and of itself. But what I always recommend is start at Rule 5.26. Work with another lawyer to be able to come in and do these things. If something happens to you, how is your successor lawyer going to come in and discharge the duties of the trustee assigned by the court under Rule 5.26? Do they know where the keys are? Do they know where the passwords are? I'm not saying that they just have them. I'm saying that they know how to get them in the event that they need them. Is your staff comfortable with that individual and know that that's the individual that they need to be liaising with if something happens to you? All of those kinds of issues, I think, are farther up the ERM ladder of topics to address in the present environment. And why do I recommend 5.26? Is because the successor lawyer has immunity from malpractice and discharging the duties. Immunity goes away if the individual client that was the former lawyers becomes the successor lawyers. That's a different issue. And then some issues in practicing law in the uncertain economy. But finally, I just want to leave you with the possibility, if you have additional questions, or other resources out there as well. And Rob, that concludes my time. It doesn't necessarily conclude all the information that's available out here at all. Thank you for the opportunity. And once again, castigameier@thebarplan.com if there's anything I can do to help further.
I want to thank you for a terrific presentation, and folks, take a good look at the materials. I think you'll get quite a bit out of it. To all of our attendees, thanks for coming. We look forward to seeing you April 15, and then again June 24, which will be a full day program. We will be sending a evaluation to you. Most important thing for us, tell us the types of programs, both topics and speakers that you would like to see. We craft these to meet your needs, and we'll work to put on another terrific program. I wish everyone to stay safe, be well, and we'll see you the next time. Thanks so much. Have a good day.